Welcome to Lesson 4 in this series, covering American government and politics. The lesson has been created to support the teaching of A-Level politics. In this lesson, we consider the process of amending the Constitution. By the end of the lesson, you should be able to answer the following questions. What formal methods are available for amending the U.S. Constitution? What informal methods exist to amend the Constitution? What are the advantages and disadvantages of the formal procedure for amending the Constitution? And is it too difficult to amend the Constitution? The formal process of amending the Constitution is outlined in Article 5. It provides two means of proposing and two means of ratifying an amendment. An amendment can be proposed by one of two methods. Firstly, Congress can propose an amendment, passing the measure with a 2/3 majority. Or secondly, a national constitutional convention can be called to propose an amendment. A national convention can either be called by Congress or by 2/3 of state legislatures. All amendments so far in American history have been proposed using the first method, with Congress initiating the process. A proposed amendment must then be ratified by the states. This can be done in one of two methods. Firstly, 3/4 of state legislatures can ratify the amendment. This must normally be done by a deadline. Or a second possible method is for state constitutional conventions to convene. 3/4 of these state conventions must then ratify the amendment. A successfully proposed and ratified amendment will then become part of the Constitution. There have been 27 amendments to the Constitution since 1787. The first 10 amendments were all ratified in 1791 and are collectively known as the Bill of Rights. However, the Constitution can also be amended through an informal process. The first of these informal methods is known as congressional action, whereby actions of Congress are accepted as compatible with the Constitution. Over time, Congress has exploited the vagueness in the Constitution to extend its powers beyond those formally outlined in the Constitution. For example, the Commerce Clause of the Constitution gives Congress the power to regulate commerce among the several states. This clause has been used on many occasions to legitimize federal action by Congress in ways that the Founding Fathers did not necessarily consider. For example, the Commerce Clause was used in 2010 as authority to pass the Affordable Care Act. This was a significant healthcare and health insurance reform. The Founding Fathers would not have envisaged the clause permitting federal action to this degree. Presidential action is a second means of informally amending the Constitution. Similarly to Congress, presidents have used the vagueness of the Constitution to extend their powers beyond those originally enumerated in the Constitution. A good example are the president's constitutional powers as commander-in-chief. These have developed over time from purely commanding the army in battle to give the president the authority to deploy troops abroad, often without formally declaring war. For example, President Biden ordered military action against Houthi targets in Yemen in 2024 without congressional approval. This is an aspect of presidential power that was probably not envisaged by the Founding Fathers. Finally, and perhaps most importantly, the Constitution can be informally amended through judicial review by the Supreme Court. The Supreme Court has the power of judicial review. This means it can strike down any law or executive action that contravenes the Constitution. Thus, the court can change its interpretation of the Constitution as societal values change. The Constitution therefore changes with the times. For example, in 1896, the Supreme Court ruled that segregated, separate but equal facilities for African American citizens were constitutional. However, this decision was overturned by the court in Brown versus Board of Education in 1954. The Constitution was reinterpreted by the court to outlaw segregation. Now let us consider what the advantages and disadvantages are of the formal amendment process. A principal advantage of the formal amendment process is that it requires broad support. Supermajorities ensure that there is a genuine national consensus behind changes. Amendments require bipartisan support at both the federal and state governmental levels to succeed. Broad support is important before making changes to the foundation governing document of the country. However, the process can undermine the principles of majoritarian democracy. The supermajorities required to pass amendments mean that proposals with significant public support do not necessarily succeed. For example, Pew found that 78% of Americans favor the Equal Rights Amendment, but it has not reached the three-quarters supermajority required in state legislatures. This is important because it can leave the people frustrated that provisions of the Constitution do not keep pace with changes in society and popular will. Another advantage is that the formal amendment process protects the Constitution and its principles. Supermajorities protect the constitutional principles from being undermined. Separation of powers, checks and balances, bipartisanship, federalism, and popular sovereignty. This is important because it protects government from tyranny and demagoguery as the Founding Fathers intended. However, it is difficult to change outdated provisions of the Constitution. Some aspects of the Constitution are widely seen as archaic and no longer fit for purpose. However, the lengthy amendment process makes it difficult to update the Constitution. For example, the Barceller Amendment in 1969 proposed changing the Electoral College. However, it then failed to pass Congress. But Americans want change. According to Pew, only 40% of Americans favor keeping the Electoral College. This means that the Constitution cannot adapt to modern times and that significant issues are left unresolved. The formal amendment process ensures that individual and state rights are entrenched. The lengthy amendment process protects individual rights from being undermined. For example, in Texas versus Johnson, in 1989, the Supreme Court ruled that flag burning is a form of free speech. Efforts to introduce a constitutional ban have failed, despite 56% of people supporting a ban. Religious freedom is similarly protected by the Constitution, despite attempts to amend the Constitution to permit school prayer. Requiring the support of states also protects states from changes imposed by the federal government. However, entrenchment of rights means that it is hard to change rights to reflect modern values, culture, and society. For example, the need for a well-regulated militia justifying the Second Amendment has arguably passed. Pew found that 58% of Americans favor stricter gun laws. However, future restriction on the constitutional right to bear arms is unlikely. The amendment process prevents frivolous amendments or those covering transitory issues. It is important that the Constitution is difficult to change, to protect it from change inspired by demagogues or temporary short-term changes of public opinion. For example, a proposed amendment in 1838 to ban dueling failed. Although dueling may have seemed very important in 1838, it is now a historical problem. The complicated amendment process prevented such a transitory issue from being included in the Constitution. However, the amendment process is not immune to allowing frivolous amendments to pass. The amendment process still permitted passage of the 18th Amendment, which introduced prohibition a ban on alcohol consumption. This was then reversed by the 21st Amendment. A final advantage of the current amendment process is that review by the Supreme Court allows reinterpretation and adaptation to modern values. The unspecific and vague nature of some parts of the Constitution permits informal amendment through judicial review. For example, the right to gay marriage was introduced by judicial review in Obergefell versus Hodges in 2015. However, rights granted by judicial review are not entrenched. Rights granted by judicial review are not entrenched. They can be overturned. Ultimately, it requires a constitutional amendment to provide strong protection to rights. For example, the right to an abortion provided by Roe versus Wade in 1973 was overturned by the Supreme Court in 2022. However, such occasions are very rare. Of more than 25,000 decisions since 1789, the court has only overturned 235 times. That is less than 1%. In summary, the Constitution can be amended formally through the measures outlined in Article 5 or through the informal processes of congressional action, presidential action, or judicial review. The formal amendment process has several advantages, ensuring broad support for any amendment, entrenches state and individual rights, and prevents frivolous change. However, it can prevent the Constitution from changing to reflect modern societal values and needs.